In the Cherokee Funding, LLC v. Ruth, Case No. A17A0132, decided June 27, 2017, the Georgia Court of Appeals evaluated at how those businesses are in line with Georgia's statutory schemes regulating certain lending activities. Conclusion was that this type of litigation funding did not align within two sets of Georgia statutes regulation loans. In recent years, litigation funding industry has evolved in which businesses loan monies to plaintiffs with pending lawsuits in exchange for a share of the recovery. The business only receives money if the plaintiff makes a recovery. Business gets nothing if the lawsuit fails. Separate agreements were made between the plaintiffs and the defendants to receive several $1,000s if they get any recovery in their lawsuits. After the settlement, the plaintiffs found themselves indebted to pay the defendants many multiples what they had been advanced. The plaintiffs argued that the agreements violated the Georgia Industrial Loan Act and the Payday Lending Act. The Georgia Court of Appeals concluded that those acts did not govern the agreements. Both of the acts applied to loan agreements. The court concluded that a loan was an agreement to advance money that necessitated repayment. Nevertheless, the funding agreements at issue required repayment only if the plaintiff received a recovery. If the plaintiff achieved no recovery, no repayment was due. The court stated that the defendants took the risk of receiving no recovery, and thus the agreements were investment contracts that was outside the scope of the acts. The court concluded that it was Georgia legislature that must decide whether funding agreements of this type should be regulated.